Thank you very much. It's such a pleasure to be here. I speak to a lot of different groups, but I think this is one of the ones that I enjoy the most, in large part, and not despite the fact that Herb is heavily involved in it, but despite all of that, I like the fact that this group thinks it's important enough to not only highlight the Sunshine Law, which is the one that most elected officials work with, but also the Public Records Law. And increasingly, I think especially as governmental agencies are looking at technology issues, it makes even more sense to combine these two, because inevitably people are not going to just want to be a part of or attend your meetings, but they're also going to be requesting public records, sometimes based on what they hear there, otherwise based on what they see online. In any event, Floridians have a history of wanting to be involved as much as they can be in both the Sunshine Law and public records access issues that they face. So let's take a look first at Florida's Sunshine Law. Looking at our Sunshine Law, we are the most open state in the country. I've been asked by congressmen throughout the nation to give me some information about our law because they would like to replicate it in the federal government. And I used to spend a lot of time with these congresspeople explaining what our law did, and once I did that, they never called me back. And I realized that to save my time and theirs, I should really just say two things before they hung up and did not call me back. And one is the breadth of our Sunshine Law, applying to any gathering of 2 or more members of the same board to discuss some matter which will foreseeably come before that board for action. And 2, there are civil and criminal penalties that result when it is violated. After I say those 2 things, the congresspeople, it used to be if the Democrats were in charge, it was always Republicans calling me. If Republicans are in charge, it was Democrats calling. Whoever is on the outs generally wants more access, but they would not call me back. But here in Florida, members of the public love our Sunshine Law. If I was speaking to a group like this one and I wanted to know how many people in the room are from the government and how many people are ordinary citizens, I would just have to ask this question. How many of you think that the Sunshine Law is inconvenient and bad public policy? Government officials, elected or appointed, would raise their hands. Members of the public, no. In fact, they want even more openness, as many of you already know. Many members of the public, if they see 2 commissioners together, even if they're married, which is somewhat, I guess, a scary thought, they would say they are violating the law because they're talking to each other. But the Sunshine Law is limited to those discussions between 2 or more members of the same board to discuss matters which will foreseeably come before that board. But you can see how broad a standard that is. There is no discussion if it affects county commission business that is too informal or casual to be outside the Sunshine Law. The importance is not a factor. So this is something that takes the Sunshine Law into the realm of being something that county commissioners, really officials who are part of any public board, always need to be cognizant of. If there's another member of their board in the room, people are going to be thinking about the Sunshine Law. And I would have to say, much as I respect and love my friend Herb Thiele, I would disagree with him when he suggests that a matter that has already been voted on can be the subject of discussion between 2 county commissioners. For this reason, I think that it's impossible to predict for certainty whether or not that particular issue is coming back before your board. There may be factors that you might not be aware of, but the county attorney might know, for example, that a rezoning that you did 2 years ago has now resurfaced by different applicants and is coming back before you. So my suggestion would be to not talk over any issue that could come before the county commission for action, even if it's one that has already been voted on. And I know that this is just one more circumstance that in many ways makes collegiality sometimes a difficult goal for members of county commissioners. I teach a class at FSU, and one of the members of the class is a county commissioner. And he has reiterated this to me when I mentioned this, how difficult it is that when you really want to talk to somebody sort of man to woman or just person to person about why they feel a certain way and what motivates them, the Sunshine Law makes it difficult. But one thing I think that is important for us all to keep in mind that I know you've already thought about, this is the way the public wants it. When the public had an opportunity to put the Sunshine Law and public records law for that matter in the Constitution to prevent the legislature from eroding it more than they thought was necessary, they jumped at the opportunity in 1992 and by over 80% agreed to place the Sunshine Law within what is effectively the Bill of Rights in the Florida Constitution. So moving ahead to the next slide, 3 basic requirements. All of these, I'm sure, are said often to you. One is that meetings of the boards must be open to the public. Reasonable notice must be given, and minutes must be taken, promptly recorded, and open to public inspection. Items 2 and 3 are taken care of by the staff. The staff is the one that notices all the meetings in compliance with the Sunshine Law or any other statute. As you know, there's more than one that tells you sometimes what kind of notice you have to provide. And they also keep the minutes. Now, one issue that sometimes comes up, I know from people who call my office, is this scenario. They say, I spoke in front of the county commission and I made several very important points and I spoke the allotted time I was allowed to speak, and when I see the minutes, I notice it just says, Joe Brown spoke. So they violated the Sunshine Law, didn't they? And I say, no, they did not. The Sunshine Law does not require that every single discussion be recorded, word for word. The minutes requirement only is a brief summary of what took place. So that doesn't mean that everything has to go in there. Now, some boards will put everything in there, in the minutes that occurred in lengthy discussions, but that is not a Sunshine Law requirement, nor is it a requirement under the Sunshine Law that meetings be televised or that there be an internet display. Now, are those things good to do? Absolutely. They increase transparency and are a real benefit to those people who want to watch what's going on. I'm resisting the urge to say they have severe sleep problems. I'm not going to say that, but they do. Some people do want to watch on on a TV station, and many county commissions provide that service as well as an internet webcast, or they provide a transcript not only for their meetings but for advisory committees as well. So those kinds of transparency initiatives are good, but they are not required by the Sunshine Law. The important provision of the Sunshine Law that boards and their staffs have to remember is meetings of a board covered by the Sunshine Law have to be open to the public, and it's that term meeting as defined and interpreted by our Florida Supreme Court some 40 years ago. Every now and then, I get a call from someone who has moved to Florida from another state, lucky for them, except on a day like this. Normally, it's almost always better in Florida than wherever they are from. They have been elected to public office in Florida, and they say, our attorney keeps talking about the Sunshine Law like it's some big deal. And I notice when I read the law, this is especially true if the out-of-stater is an attorney, and it says all meetings at which official action is taken. So why is it 2 or more members to discuss anything? And I'll say, because that's what the court said. As Herb pointed out in his analysis, early on, in opinions that are filled with discussions about the importance of the democratic process and a democracy, the courts reiterated that it's the entire decision-making process that should be covered by our open meetings law, and that can only be done if the law applies to 2 or more members of that board to discuss any matter on which foreseeable action can be taken. And it's that standard that still governs us today, and it's that standard that the individual members of the board have to comply with. That's one of the many great things that I think the FAC organization does, is emphasize the kinds of resources and training that really go to focus on individual responsibility, which is extremely difficult, I think, in light of a lot of the challenges that are faced by the county commission as a group, problems that you have to address, real issues affecting people within your communities. But notwithstanding that role of the county commission, the ethics and sunshine and public records law impose that additional responsibility as an individual to ensure compliance. How can that be made easier? Through the kinds of trainings, not dronings on, that we're having here today. One of the earliest decisions of the Florida Supreme Court, after it ruled on the very broad application of the Sunshine Law that we've been over before, is that the law doesn't just apply to the elected or appointed boards, but it applies to advisory bodies created by those boards, even though these advisory boards have only the power to make recommendations. This is yet another area that it distinguishes us here in Florida, I say for the good, from the rest of the nation. Many of them reserve their open meetings provisions to the actual elected or appointed boards, and advisory bodies are considered in those states almost like a private entity. Not so in Florida. In Florida, when citizens are selected to serve on an advisory board, the message to them should be something like this: congratulations, we're happy to have your help. But you and all the other members of your advisory board are now subject to the same Sunshine Law standard that we are on the county commission. There is no lesser standard for them. In other words, nobody gives them the allowance to say, well, it's really hard for these citizen advisory boards to know when that they're supposed to notice their meetings, or to keep minutes, or to remember that they can't discuss advisory board business with their friend and colleague as they have for years, simply because this friend is now on the advisory board with them. So what do I think is the responsible thing to do at this point? Make sure these advisory committees know this. In some areas, people are put on these committees, and this fact, the application of the Sunshine Law, is not explained to them. The fair thing to me is to tell them, if possible, to have a short little briefing, maybe just the first page of like this slideshow, the first and second page. You can't discuss board business with somebody else, notice your meetings and keep minutes, and ask the staff to help them to notice these meetings on your website, for example, in the same way as other meetings are noticed, so that these people don't run the risk, if somebody disagrees with the recommendations that they're making, of saying that these well-meaning public citizens have somehow violated the law because they didn't know they were supposed to notice their meetings. Yes?
Is it enough to notice the meetings on the website, or do you still have to do it as a legal notice in a publication?
That's a very good question. Commissioner Lindley has just asked, well, can you notice advisory board meetings on your website, or do you have to publish it in the newspaper? The Sunshine Law requires only reasonable notice. So presumably there, what the courts say is you're looking at the type of notice that would enable a reasonable person to know that there was a meeting in sufficient time in advance to be able to go. So it's obviously a lot more than a half hour beforehand, oh, by the way, we're having a meeting, but it's not perhaps quite the same amount of notice as would be required, say, for county commission meetings, which are often noticed in the newspaper, not because necessarily the Sunshine Law may require it, but because for certain types of actions, as you know, millage, I'm thinking, or ordinances, more notice is required by other laws. So to me, the simplest way to deal with this is to have the staff just be sure that where they have these advisory committees, that they are being noticed with reasonable notice. My own view is that for a lot of them, probably notice on your website might be sufficient. I'm thinking of an advisory committee that someone called me about a while ago to decide what kind of flowers to plant in the medians of the roadway. I'm thinking that's a fairly small interest group there. Maybe noticing it on the website, probably good enough. But with regard to a planning commission, for example, there the staff is going to publish that in the newspaper as well as take other steps. So with every case, with notice, you're looking at reasonable as your standard. Yes?
What would be deemed reasonable?
Well, you know, that's almost like a life question. But but in answer, people ask that all the time. And of course, the legal standard is the amount of notice that would enable someone to have a reasonable opportunity to attend. But I think what I would do is that then people say, well, what does that mean exactly? I would say, suppose you had to explain to a judge as the county attorney the type of notice that you gave for a particular meeting. And would the judge find that the amount of time, advance notice that you provided, and where you published it was adequate? Now, clearly, if you publish it in the local newspaper 7 days in advance, you're not going to get any challenges. So that's why a lot of people, because you're in the newspaper, everyone can see and read. The newspaper is deemed to be public notice in many cases. And if you stick it on your website, you do those two things, you've noticed the public. It's when people, perhaps you see this sometimes with these advisory committees, if they are not in a position to use your staff in a way to make sure their meetings are noticed, they may come up with their own idea of notice. Well, sometimes that means noticing their friends and people they think are going to support them. So that may not be notice to the general public, might be just notice to sympathetic ears. So in every case, it's really almost like everything else you do, isn't it? You're looking for that standard of reasonableness as you explain to the public why you have done things in a certain way. With regard to the Sunshine Law, with most advisory committees, this notice issue does not come up. The big issue that I see with advisory committees, I mean the type of notice, is that they don't know they're subject to the Sunshine Law sometimes. So that's where you can be sure that they do know this and they don't result in something happening with regard to a complaint against them that nobody wants to see. So this is one of these areas where you can go back, just ask your staff, or staff if you're here, to check to be sure that there is a mechanism. Sometimes it's a little training for these groups to know that the Sunshine Law applies to them, that they don't need to be frightened of it, and that the steps can be taken to make sure that their meetings are noticed, simple minutes kept, and the most important thing, as you might guess, they don't talk to each other about public business. They don't use the telephone, they don't email each other, they don't get on each other's Facebook blogs, etc. All right, here is a point that whenever I discuss this, usually there is somewhat of a hiss in the audience. It's happening as we speak, for those of you watching the film presentation. And that is the legislature and the courts not subject to the Sunshine Law. Both the legislature has a constitutional amendment that applies to them. Is it as strict as the Sunshine Law? No, it is not. Their Sunshine Law provision applies to any gathering of 3 or more legislators. It's prearranged and they are taking some sort of formal action. Not as strong a standard. The courts also not subject to an open meetings requirement. That's why TV cameras can't go right into the jury room or into the judicial chambers of the Florida Supreme Court. But constitutional provisions relating to a free and open, or an open trial, are also there. So other constitutional provisions control these other constitutional entities. The court saying that that is based on separation of powers principles. Staff also not ordinarily subject to the Sunshine Law. Every now and then members of the public call my office and would like to be able to attend a staff meeting, say in the building department, for example. The Sunshine Law applies to meetings of public boards and commissions. It does not apply to staff because they are not, maybe in some areas staff thinks they're members of a board or a commission. We used to have, when I was a cabinet aide, we used to have members of the public that we felt sometimes they were, that they felt they were a member of the governor and cabinet, but they are not. And so, just because staff has a role with regard to providing information, even recommendations to you, does not make them you and a member of a board of county commissioners. But occasionally, as with any other advisory committee, it's possible that staff could be placed on an advisory committee and become subject to the Sunshine Law for that purpose, or within staff. Within the administrative offices, sometimes there are committees created within staff. Purchasing and personnel are the ones that come to mind, for which there can be Sunshine Law implications. Staff members who have questions about whether or not that's occurred can go to the county attorney for advice. Generally, the areas where you'll see that issue occur is if, for example, in county administration, a procurement committee is created, a procurement committee that shortlists, for example, bids or proposals for consideration by the county commission. Sometimes the courts will consider those purchasing committees, procurement committees, to be a part of the decision-making process. It's too complex to get into here, but if we do have staff members here and you do have committees like that, you want to go back and just think about whether or not the Sunshine Law could be applying there. Most county attorneys have already done more or less a sweep after these decisions started to come out a few years ago to research that issue. Why do you think you see that Sunshine Law issue so much in those two areas, procurement and personnel? It's because it's the one area where the government is likely to do something very disappointing to an individual, and they may use the Sunshine Law as a vehicle to challenge that decision that perhaps went against them. A personnel committee, for example, fires someone, that person may not say, well, gosh, I guess my performance was not really satisfactory. They may question whether or not the Sunshine Law would give them an avenue to file a lawsuit. Those two areas is sometimes where you see that principle. We've discussed the broad scope of the Sunshine Law, and perhaps another one of the areas that distinguishes us from other states is the inability of boards in Florida to take themselves out of the Sunshine Law, or to, as is done in so many other states, go into executive session. When I am visiting relatives in the Northeast, I like to look at the local paper up there, and almost always there's an article that says that some board is having its monthly meeting, and all of a sudden one board member says we need to discuss the county manager's performance, and at that point all the members of the public are escorted out or told to leave, and the board goes into executive session to discuss this issue. They do that because they want to, and that's the law in that state. Presumably, when I said they want to, I'm oversimplifying things. I think the view of the board is in those states is probably similar to what any employer would want to do. They would like to freely discuss performance without having the employee able to listen in, and they would also like to perhaps discuss embarrassing details about performance without further embarrassing the employee and doing this in front of the public. So in those states, that is not unusual. Can that be done here in Florida? Absolutely not. There are no circumstances under which a board can close any part of its meetings, Robert's rules notwithstanding, that doesn't trump the Sunshine Law, unless the legislature has created an exemption. And all of you well, I'm assuming most of you have been through the two major times you see that happen. One is where the county attorney says it's essential to discuss settlement or litigation expenditures in pending litigation. And the second might be collective bargaining strategy sessions. The actual collective bargaining that goes on between the employee's representative and the employer's representative, that's public. But the legislature about 20 years ago decided that the public employer, in that case you, should be able to meet with your representative during actual collective bargaining to discuss strategy, etc. So those are the two main examples that can apply to county commissions. The legislature added a third one, procurement. Some procurement types of actions, vendor interviews in particular, can be held outside the Sunshine Law. Many of these are subject to conditions that must be complied with, like a recording, or in the case of procurement, or with the attorney-client exemption. As you know, the certified court reporter comes in there. Unless the legislature has said it's okay, though, no other reason. Even things that might in other states, it probably is incredible that in Florida, when the Board of County Commissioners wants to buy real property, the owner of that property can be right there in the audience and see what you're willing to pay. Now, there's some exemptions at some point for the appraisals, but these actual real estate discussions, whether to buy or sell property, all conducted in the open. I think that one reason why we don't have an exemption for that here in Florida could be the history of land fraud in Florida. One of the things that was probably a part of our history back in the 20s and 30s We have many distinctions in Florida, I think nationwide, and probably one was being the land fraud capital, if that's the way to put it, back in the 20s and 30s. All those little communities that were established all over Florida designed to entice northerners looking for nice weather to come down and see basically a big wetland and or swamp, depending on your point of view. So that is what I think that philosophy perhaps means, that we will not see an exemption in that area recently. The other reason I think you don't see an exemption for that here in Florida, you probably already thought of the same thing. Anything that involves the expenditure of money, people feel that's my money, and I want to see every single thing that goes on with my money in front of me. So I think that's probably another reason why you see so few exemptions enacted by the legislature from the Sunshine Law. More with the Public Records Law, as Herb pointed out, over 1,000 exemptions from the Public Records Law, which provides an opportunity to discuss another anomaly about Florida law. And that is that an exemption from the Public Records Law does not create an exemption from the Sunshine Law. Each one has to be separately provided. So for some boards, like a pension board, that can mean a confidential record must be discussed at an open public meeting. So also the courts have pointed out, I think in response over the years to concerns by members of governmental boards about how they can act properly in the sunshine and still protect some measure of privacy, the courts have basically eliminated any thought that this could be done. Some boards, in trying to avoid a public discussion of a personnel matter, for example, tried to use pseudonyms, like, we need to discuss the case of employee X. In one particularly bad example, the court said, no, you can't say employee X. The name of the person cannot be withheld. If a member of the public wants a public records request, then they can make a request for all of the records. And using pseudonyms and things of this sort are things that have been disapproved of by the courts. Board members cannot use email or the telephone. You can see this outline really needs to be updated, or text, or use Facebook to conduct a private discussion about board business. This is a particularly timely topic, and I think one that concerns a great many people today. There is a county commission that is right now struggling with this issue, where commissioners allegedly exchanged text messages about a controversial issue in front of the county commission. Communicating back and forth via text message about board business is not allowed under the Sunshine Law. What has happened in this case involving this county commission, as I understand from just news accounts, is first, concerned citizens became aware of the fact that there had been text messages potentially, I don't think anything has been proven yet, through public records requests. Text messages about board business are public records. So at that point, the state attorney weighed in after a complaint was filed with that office. The last I read, the Florida Department of Law Enforcement was called in to investigate. One thing that was done was to impound the commissioner's cell phones for forensic analysis. The thing about this that is, of course, it's sad from many, many different aspects, but to me, it shows how probably the entire county commission is virtually paralyzed and unable potentially to as effectively deal with the issues that it has to deal with on behalf of its community, because these commissioners are dealing, as a result, the entire commission, faced with this investigation inquiry into the text messages. All of this, as I'm sure you're agreeing with me, could have been avoided had the commissioners refused to text, especially on their own personal cellular phones, about board business at all, especially not with each other, because it violates the Sunshine Law. I cannot stress enough how avoiding using these technologies to discuss board business, if it's with another commissioner, is illegal and is easy to determine that it occurred. I mean, the forensic analysis can be done. It's simply not productive. I recognize that commissioners, like any other public officials, may sometimes receive unsolicited text messages from constituents. It's easy to get your telephone number. That's one reason why you're there, because you're people that the people in your community want to communicate with. So what should you do? Here's advice number one. Don't use your personal cell phone or computer to communicate with constituents. If you do, I mean, if a constituent sends you something that you didn't even ask them to, I know that occurs. If you don't have software to convert the text message, I know I don't, into email on your government server, take a picture of it. People do this. Take a picture of it with your phone, send it to your county administrator's office, or if you can send it into your email, do that. Do something so that if you get a public records request for all communications that you have sent, and they will, this is how they'll be worded, via email, via text. They might even throw in hard copy if you're a dinosaur like me who might have written something in a letter form, and text messages. You can respond. All of those materials that I have sent or received relating to official business as a county commissioner are on file at the county administration offices. When you do that, then you comply with the public records law. The second thing to do is not use those technologies if you're not capable of keeping them as public records. Then don't use the technologies. And don't use the technology, especially text messaging, one commissioner to another. At first, perhaps like you, you're thinking, well, who would do this? Well, I think it's sometimes easier to happen than people think. Unlike maybe 10 or even 15 years ago, when communicating without a phone call was a time-consuming task. I mean, you really had to think about what you were writing. Even with an email, it's a little bit slower than a text message, but I think sometimes people just get caught up in the moment, and they send a text message without thinking about it, and that's when difficulties arise under the Sunshine Law. Obviously, the telephone, the same thing, not a public record. People do ask me that. Someone calls you up on the phone as a county commissioner. Do you have to somehow record that call? No. You probably shouldn't, actually. But you don't have to summarize it. A telephone call is not a public record. But if you telephone another commissioner, that's a violation of the Sunshine Law. And I would have to say very few people these days telephone other commissioners about board business. Obviously, if you telephone to say, by the way, the Florida Gators lost to Michigan, ha, ha, ha. So not that that would ever occur. Probably not a Sunshine Law violation. It may result in some sort of consequences, at least with some members of my family who have been doing that, maybe. But on the other hand, the telephone sometimes is a problem with these advisory committees, but not the elected officials. The Sunshine Law can apply to a single individual. The one example that Herb gave is that if a single individual is authorized on behalf of the commission to act on its behalf, that makes sense. It's as if that single commissioner is carrying the entire commission with them, just acting on their behalf. The second is if a single member of a board uses a non-board member or staff as a liaison to pass views from one person to another. This is not something that's done so much anymore. In the early years of the Sunshine Law, this was seen as a way that boards could somehow violate the law. They said, well, we've heard that the law applies to 2 or more board members. We'll get around the Sunshine Law by simply asking staff to go around and get consent from all of the other board members or pass views from one board member to another. And the courts quickly said that would violate the Sunshine Law. Sometimes people ask me, well, what about newspaper reporters? They call around all the time, and they'll call Commissioner A and say, well, what do you think about the Acme development? And then they'll call Commissioner B and say, well, Commissioner A told me that he's in support of the Acme development. What about that? Is the newspaper reporter violating the Sunshine Law? No, because the newspaper reporter is not being used by staff or by the commission to communicate views from one person to the other. If an outsider comes in and does that like a newspaper reporter, then that does not violate the Sunshine Law. Written ballots are okay, but a secret ballot is not. So sometimes boards like to use written ballots. I know it was something that the governor and cabinet used to like to do when they made selections for some of the agency positions. That's okay, but the commissioner who voted, his or her name has to be on the ballot, and the person or thing that he or she voted for has to be on the ballot. Sometimes people want to have it hidden who voted for who. Sometimes I think that's because a commissioner might have told 2 different people that he or she favored them both. But regardless, it has to be, in other words, an open ballot, and then they have to be immediately accessible. Sometimes boards want to put this off when the press wants to know what the vote was, and everybody's entitled to know right away. The best thing to do is announce the votes right at the meeting. Commissioner Jones votes for Mary Smith, et cetera, so the tally and votes are all made public. Sometimes this is a particularly good idea when the person tallying the votes has tallied them incorrectly. So you probably think sometimes you have a lot of procedural issues. You can imagine what it's like when the city goes through the big hiring process. This is one case I'm familiar with, and announces that candidate X is the winner, and it turns out, no, they're not, once somebody checked all the ballots. So, non-disruptive video, tape recording, and photography is permitted at board meetings. Sometimes I've heard of cases where commissioners have seen their city commissioner saw her political enemy in the audience, tape recording her, and she went down from the dais and pulled the plug from the wall. You can tell this was a few years ago. Now nobody would know who's being taped, but this was a violation of the Sunshine Law, and as a result, the City Commission had to go through a lengthy training like this one. This is like a no-brainer, is it not? Hold board meetings in buildings that are open to the public, not private homes, or like people sometimes have called me about, a golf club. Obviously, that is a closed country club, for example. Open public buildings are the places to hold meetings. The phrase open to the public means open to all who choose to attend. I put this slide in here because every now and then a board will ask me whether or not it's possible to invite the public, of course, to attend their meetings, but they would like to exclude some members of the public or a member of the public. Particularly, this comes up in the context of perhaps an employee or someone that has an issue with the county commission. And the courts have answered this question by saying that a meeting is either fully open or fully closed by the legislature. There are no intermediate categories, so the meetings have to be open to all. I think Herb already discussed penalties this morning in great detail. Did he show his booking photograph of the former senator? Yes, I imagine that was huge there on that projector. So the penalties are there in the slides primarily because there are some people, I guess, that have not been through this with Herb, that really think that the Sunshine Law is just something that's like a rule of procedure designed to make people feel good, like a good government. And it's much more than that, as you can see. A knowing or intentional violation is a second-degree misdemeanor. I see every year in the press releases from the governor's office that members of a city commission, usually it's a majority of the city commission, suspended or removed from office because of violations of the Sunshine Law. Even an unintentional violation can be prosecuted as a non-criminal violation. I think virtually all of the state attorney's offices would much rather have commissioners like you that already are concerned about compliance with these laws. They know they're going to do it because it's tremendously work intensive for the state attorneys to do the investigation of these cases if a complaint is filed with them for a second-degree misdemeanor penalty. The more common consequence of a violation of the Sunshine Law that I see in the cases is not so much the criminal sanctions, but rather that if a board takes action in violation of the Sunshine Law, the action is considered to be non-binding, or, as stated another way, void ab initio, void from the beginning. So this means that if a board, even if it was unintentional, took action in violation of the Sunshine Law, that the action can be overturned in court. This means that contracts have been undone, hirings have been undone, firings undone, real property purchases undone. This consequence is what I think is probably the most severe sanction that the Sunshine Law provides, because you can imagine what an interference with governmental processes such a result can occur, particularly in those cases with a procurement where a bid is awarded and then has to be undone and done all over again. The courts have said, in recognition that this void ab initio consequence is so draconian, the courts have said, though, that a board, if it has taken action in violation of the Sunshine Law, can effectively cure that violation by taking independent final action in the sunshine. So this means more than just merely ratifying what was done, i.e. the county attorney getting up there and said, well, we had a Sunshine Law issue with the contract approval, so let's all vote again and cure it. It takes more than that. It's almost like the courts force you to undergo a little bit of a punishment in return for the violation. Full, independent, final action usually means public hearings or some sort of lengthy discussion of the matter, i.e. where you try to put before the public the basis for your decision, so that in that case, then, if the court agrees, you are curing the violation of the Sunshine Law. In most all cases where there have been inadvertent violations, I've seen boards do this over the years. One impact of it is that boards shouldn't panic if they find out that for some reason a meeting notice did not get out. This procedure is in place there so that the boards can rectify, if they do it the proper way, an action in violation of the Sunshine Law. The court's recognizing that that occurs sometime. The only time I've seen a court refused to allow, in this case was a hospital board who discussed behind closed doors a merger. The public hospital board was not permitted to cure the meeting, and instead the whole process was undone. The court saying something like there were so many violations for so long that no amount of sunshine could cure the clouds that fell over the board, or something extremely dramatic like that. But that's an unusual situation. In most cases, boards do cure the violation of the sunshine law, or the alternative is the board has mistakenly had a meeting that was not in compliance with the sunshine law. This comes to light several weeks or months later, and then the court will sometimes say, well, we've seen that in the interim a whole lot of public discussion was held on this issue, and they say that the board essentially cured the violation without even knowing that it did so, which I think is sort of shows that most, as a point that I really believe strongly, that the overwhelming majority of members of local boards work very hard to comply with all of these laws and mandates, and the court's recognition that the circumstances where there's a problem are few and far between, and that's certainly true with the sunshine law. If after this session you're thinking, I'd like to learn even more, actually I've never heard anyone say that. These are some sources of information for you. There's two. One is our website. Of course, we have the Sunshine Manual there online, which some of you, if you don't have a copy of your own through your county attorney's office, you can look at that online at our website. Also, Governor Rick Scott has a lot of information at his website. And one thing that you might find particularly helpful if you have an issue with a state agency, I'm saying that, of course, who doesn't? Most people would say that. But he has an open government contact list there. And that's a good source for information just to call. If you want to know to call a particular person, generally if you call the open government contact, say for the Department of Business and Professional Regulation, even if your real issue is with condos or something like that over there, or licensing, that person will probably get you to the right person. The First Amendment Foundation website has a lot of information there as well. One that's particularly helpful is they will keep track of all of the open government legislation. So I know you already get probably a service through FAC that gives you information about bills and laws throughout the process, but they have probably the best insofar as the open government laws. I think because they're a foundation, they're not permitted to comment like for or against or advocate, but they'll have like a little sun by the ones that they like and a cloud by the ones that they don't. Now, one of the things that's coming this session that they have a big sun by is Senate Bill 50, which will provide that all boards subject to the Sunshine Law must provide an opportunity for public participation. Right now, as all of you may already know this, the Sunshine Law does not require that governmental boards subject to the Sunshine Law, county commissions, for example, provide the public with an opportunity to speak at county commission meetings. The courts have said the Sunshine Law is a law that allows the public to attend, but does not afford a right to speak. As a result, there's been legislation pending the last 2 years that would change this. Last year, the bill sponsored by Senator Negron passed the Senate, but because it was generally felt that Speaker Cannon opposed it, it never made it out of the House of Representatives. This year, Senator Negron has sponsored Senate Bill 50 that I think the Association of County Commissioners, or FAC as well as the League of Cities have been involved with this heavily and have done some amendments, I believe, that they've submitted to this. It's in the Senate, and Speaker Weatherford, who was a member of the Open Government Study Commission, which recommended this several years ago, has indicated that he's in favor. So for those of you that have not looked at public participation, I really don't know of a county commission that doesn't provide an opportunity. Sometimes I think it shows a lot of patience sometimes by the county commissions that they do this throughout this state, recognizing that even though there are some people that are disrespectful, the vast majority of Floridians appreciate the opportunity to address their public officials. Most county commissions already have this, but for those that don't, or perhaps some advisory committees may wish to start looking at this legislation and seeing whether or not to tweak your public participation policies to make sure that if this bill goes in, becomes enacted into law, that you're in compliance. My guess is, from what I've seen of it, it seems to basically track what a lot of the local governments already do. Time limits are authorized, but it basically provides people an opportunity to speak on the issues that are going to be voted on, something that most people, I think, would think is a given, that governmental entities in this country would allow people to do that. So that's what we're seeing coming in the legislation this session. Let's move over to, are there any questions on public records?
I have a question.
Yes.
Let's say that our sheriff wanted me to, and I, and the county attorney, administrator, say, okay, we're going to get 8 or 10 guys. We've got a facility here that's not being used. The big day it was closed. And I'd like to get some of the people on warden from the jail and or the prison, DCI, and some other members of the community go out and go look at this facility and give an opinion of that. Am I creating an advisory board?
I think the question really was for everybody, if I can, and it's actually a quite common one. You're interested as a county commissioner in looking at whether or not an abandoned state criminal justice facility would be a good use for the jail. So you'd like to get a bunch of people together to go out to this new facility and presumably discuss it amongst themselves and give you a recommendation.
Right.
That's the kind of thing, to me, I think is an advisory committee. So given that I'm going to think that, because I have a very broad interpretation of the Sunshine Law, what that would tell me as a commissioner is to take this to your county attorney. And before you ask this group to get together, the county attorney would probably want to know, well, are you going to ask this group to meet, for example, and hold meetings and discuss this amongst themselves and then take a vote on what the recommendation should be? I think then the county attorney would probably say, well, I think you've created an advisory committee. On the other hand, if you say, well, you want all these people when they have some spare time to go over there and see what they think about it and then just call you back as an individual, maybe the county attorney would say, that doesn't appear to me to be so much of an advisory committee, but you're just asking members of the community to provide you with some information. So the county attorney would probably be looking at more whether you want a group to get together and hold a meeting and make recommendations to you. Sometimes, see, it almost comes down to, in those types of situations, what kind of decision-making you want to have as a commissioner. Sometimes, if it's a controversial issue, you might be able to say, well, look, this is how I'm managing this difficult issue. I'm getting a group of experts together as a committee who are going to sit and evaluate all the pros and cons for me, essentially, using their professional background, and give me a recommendation. Then having an advisory committee makes sense and is something that probably is good for you as a commissioner and the public to be able to see the debate among all these individuals, because everybody a lot of people are very concerned about where the jail's going to be. So then you accomplish a great deal through that means.
And additionally, if I as a commissioner want to do little town hall meetings in each quadrant within the county by myself, and I just call the community leader and say, get some people together, we've got some issues we want to talk about the jail, new fire station, et cetera, et cetera. Do I have to do public notice?
Well, the question is again, well, what about town hall meetings? What about that? I just want to get people together to listen to them. Generally, these town hall meetings, not sunshine law implicated, because you're not creating an advisory committee.
Right.
You're just going out to the community as a single individual to get input from people out there, which is something that I think is very valuable. So in that circumstance, I would not consider that to be a sunshine law situation, but
No minutes are required?
once the sunshine law is not applicable, then nothing's applicable under the sunshine law. So the one thing you want to do, though, a lot of people ask me these kinds of questions, and I love answering them, but I've learned over the years, after I get a call from the county attorney who says, I understand you've been talking to my commissioners, and it's sort of like, uh-oh, then I think, uh-oh, I've done it again. And they say, well, you told so-and-so that this happened. Did you know that this is the situation, and this is, and it's, and I'm not saying that in yours, but I always recommend bringing them in. A lot of these county attorneys, not somebody like Herb Tila or perhaps your county attorney, they really are not being, their commissioners don't contact them or their staffs, depending, and really, they're a great resource. I mean, these people, they try as hard as they can every day to prevent the county from being sued. So, yes.
So would that prevent the creation of a personalization cabinet of community leaders to give their input on issues? I mean, on a quarterly basis, if you wanted input from community leaders, that would have to be opening door into a whole sunshine?
Yeah, people have asked this question before. What about if I want to create a la Andrew Jackson? Was he the one that developed the kitchen cabinet, I think? You know, of community leaders to advise me and make sure that, I think a lot of public officials that I talk to want to do this so they don't lose touch with the people or sort of become co-opted by the administration or the staff. So I think that's in a way similar to the question that the other commissioner just asked. Because we get asked this question a lot. If you create an advisory committee and you say, for example, this is my advisory committee to go around and deliberate and evaluate various issues and then give me, especially if they're agendas, and give me a recommendation on how I should vote on particular issues. You come, in my view, very close to an advisory committee. But for most people, that's not what they want to do with these types of groups. They just want a group of close, trusted colleagues and friends that they can call upon for advice and counsel. And I don't see anything in the Sunshine Law that prevents individual members of boards from going out and talking to groups of people, from having groups of people coming to them with ideas and concerns. It's just that it's something to be cautious of, that the courts have held that a single, the case came actually from the president of the University of Florida, can in some cases create an advisory committee. It's rare when that occurs, but because it can occur, usually it occurs mostly at a staff level, frankly. The county manager creates the procurement committee, which shortlists all of the vendors for approval by the county manager, or a personnel termination committee. But it could happen, as some of you have seen, with a single elected official. Usually it's after someone is elected. Transition is what it's called, and I remember it was a real issue and concern for Governor Scott, who I think tried to a great degree to comply with all of these requirements right away as he was elected. But when you create these sort of committees, who are going to provide advice on specific issues, it does raise that problem with the Sunshine Law. I think what I would recommend, because every situation is different with these I call them single-member advisory committees, because they are so fact-specific, and because in most cases, for a single elected official, it's not going to be a Sunshine Law issue in most cases, I'd recommend you take it up with the county attorney. Sometimes what the county attorney recommends is that you make some changes in the way that your committee operates. But usually the factors that are the most important to them, it's like I can't stop talking about this topic, can I? And the main reason for that is I need Betsy to get into my next PowerPoint, or Latrice. But it's, if you're going to a specific group of people and meeting with them periodically to just go over general concerns and issues, that's one thing. But if there are specific items on the agenda and this committee is providing advice to you, then that's something to ask the county attorney about. Yes?
I have a question on the email to board members and the one-way communication.
Right.
Because sometimes I think people go way too far with that. What can be in that one-way communication that should, and for example, we may get an email from all the board members that's talking about something or something coming up, and if I didn't reply all, it says, I'm sorry, I have a conflict, I won't be at the meeting. And if someone writes, one of the commissioners would say back, don't, you know, that's a Sunshine Law violation, and I don't think it is, so.
I hear about these all the time
Yeah.
from members of the public or commissioners who ask me this question. As you point out, the opinions from the Attorney General's office have said a one-way written communication, whether by email, that's usually the way these come up, does not violate the Sunshine Law if the email is kept as a public record and there's no response. But what people call me about is someone says a short statement like, I disagree, or something like that. I think my own advice is to try to avoid these one-way communications for the exact reason that you mentioned. Instead, if, for example, you want to send something out to all the other commissioners, which is, I think, something commissioners should be doing. That's why you're there. You read something or you become familiar with a new proposal, you want to share it with people. What good does it do to just discuss it with yourself? So I recommend, though, sending those to the board clerk office or whoever distributes all your materials. Ask that person to distribute it to all the board members so it can be discussed at the next meeting. This alerts everyone not to respond back to you with substantive issues or concerns. I tell people if they're concerned about, somebody says, I have a conflict. I tell people, look, there's a lot of issues going on in Florida. Just writing back to something that's a communique and putting, I have a conflict with the meeting, who cares? Move on to better things. But the problem with sending the one-way communication is that somebody could write back something substantive. Oh, by the way, I think what you're saying here makes a lot of sense, and I hope that you will support my proposal at the next meeting. Well, see, then you've gotten into a Sunshine Law issue. And the only way to avoid having this person make a response that sort of drags you into their issue is not to send the one-way communication to begin with.
So when I was on the school board, one of the school board members emailed me a statement, I don't remember what issue it was, but it was his opinion of something. But it said on the top, this is a one-way communication, please do not respond, and then had his statement in it. Is that violent?
No, because he sent it unless somebody responded. You know, whenever I talk about this, I'm always feeling very bad that it's being videotaped, because I think somebody, if they listened to it, would just probably put it on YouTube or something, that it sounds so arcane, but the one-way communication, even if it's something like, I hope you will support me on my proposal to close this school. There's somebody saying how they intend to vote and urging other people to do the same. That does not violate the Sunshine Law as long as it's kept as a public record and there's no response. So what that school board member did is something I would not recommend, even though it may be legal under these opinions, which I have to say are written by the wonderful opinions attorneys, but they have not been public officials. And they work sort of by themselves in the Capitol, just writing these almost in a vacuum. I mean, because to me, this attorney did something, or this school board member, by writing this, he may have protected himself legally, but was it appropriate to do that and really throw that out there? And if somebody had responded and said, and not read what he said, was so incensed, which happens. We read this thing that said, don't respond, and he said, well, I'm going to respond. This is ridiculous. And he writes back, well, then they've both been in technical violation of the Sunshine Law.
So it's both of them, yeah.
That is correct. So in other words, that's exactly right. Why should somebody ever send anything like that where the determination as to whether or not you violated the Sunshine Law is dependent on someone else? I think I would not want to do that. If this is how this board member felt, I don't understand why he couldn't have waited until the board meeting to announce it and been essentially, if I know I'm offering an opinion here, a bit more respectful to his colleagues and their point of view, perhaps. Yes, sir.
Now, wouldn't the only person that would be in the violation of the Sunshine be the person that responded?
No, they're both, once you have one communicating with the other and the other responding back, you have two. So that's why it makes no sense to me to be that first person, because you are counting on the fact that nobody is going to respond back.
What if their CC, say for instance, if one sends me something, CC, but directs it towards somebody else but CCs me?
If there's a communication that goes back and forth, regardless of whether it's via a CC or any other way, it could be a violation. Now, sometimes people call me, or ask me at these sessions, and I'm not suggesting that you've done this, they ask me actual situations that have occurred. And that's another call I don't like to get, is from the state attorney's office. So every case is going to be viewed differently, potentially, by, insofar as whether or not a violation occurs in a specific set of circumstances. The courts have sometimes addressed this, emails, communications, and they tend to call them technical or inadvertent, which is what the examples both of you have are. In that, in your situation, neither one intends to violate the Sunshine Law. But that's why trainings like this are so helpful. No one wants to have to waste time. You already spend so much time doing the task that you have as a county commissioner. Who wants to waste time explaining some email or back and forth when never copying county commissioners or sending an email to other county commissioners is the preventative way to avoid a problem, rather than, it's sort of like just maintenance. That's, I guess, why you have all these trainings. So you're in a position, say you get one of these one-way communications, that'd be something I might raise at the next commission meeting to ask your attorney to advise as to whether or not that's a good idea. I mean, and have that person periodically update the county commission. If you get into this situation, which some, especially city councils do, everybody's copying everyone else, and I'm thinking, where is the city attorney? Get in there at the next council meeting and tell them to stop doing this. So that's one thing that you might do. Yes?
Kind of along the same lines, if you have a citizen and a commissioner having a conversation back and forth, and then at the tail end of the conversation, the citizen sends it to another commissioner and says, hey, this is what this guy thinks. Neither commissioner had intended for that conversation to happen. Is that a problem for the commissioners? Is it a problem for the citizens?
Well, it sounds like it's not, although I'm feeling very much like I'm in the middle of one of these math problems where a train leaves Chicago and one leaves LA and they meet in the middle. It sounds like you have there two one-way communications, but probably because people are not responding back to each other. But I think it shows the danger that results when one commissioner copies other commissioners with communications that they have and doesn't go through the board office. See, I think there's a lot of benefit to having these things to go through the board office rather than copying all the commissioners.
I guess I'm looking for, can the citizen be in trouble? If we're not using the citizen as a conduit, we didn't encourage them to do that, then I assume that...
No, I don't think the citizen's in trouble because they're not a member of your board. But see, that shows part of the problem, doesn't it? Sometimes citizens know this, and they're not always on the up and up. And so I think the citizen, if he passes things around, and he may try to stir something up. Sometimes you see this on Facebook. And I realize to a degree, you're in a situation where just by the questions that you're asking, you're not like this county commission that I described earlier that was texting amongst themselves about an issue coming, a controversial issue on the county commission agenda. Those are the things you really have to worry about. I bring up these other issues, really it just shows how knowledgeable you all really are if you're concerned about these things. The other day, I was talking to a school board and we went over this same principle that I'm always gratified to see people really looking at it in depth like you are. And this school board member said, well, you know, one of the high schools just won the state basketball championship. So I put that on my web page. And congratulations to, I can't remember the name of the high school. Maybe some of you will know it. They won the championship. Congratulations to this high school. And another school board member liked it, liked her comment. And so we're all talking about, well, is this a potential sunshine law violation? And I kept having to resist the urge to say, because you know, who cares? It's a high school that won a national championship. It's not like you said something like, well, how about the parent trigger bill, you know, or something that you're talking about, an issue that's coming before you as a school board member. So I think that to the degree that your inquiry is focused on what should we do in all possible circumstances, what I can leave you with is this, that if you don't text or email or telephone or blog with other commissioners, I can virtually guarantee you that you will not get into difficulty. These issues, these other issues that are raised will be sort of thorny ones that you will have to potentially deal with that will occupy time with people like me. But otherwise, you're going to be fine just because of the seriousness with which you approach your business. Yes?
Well, it sounds like we should put the advice together like it's 1985 and not use the technology really very much. Should we use Facebook? I mean, should we even get involved in Facebook?
I think the question is, well, first there was a comment. This sounds like 1985. I would say it's earlier than that. I mean, I think there was more technology and I don't know. But I think Facebook, so the question is, well, what about Facebook? That is clearly something where you have to keep these principles in mind. There has been litigation involving governmental entities where public records requests have been made for city commissioner Facebook blogs and comments where they commented about an issue or proposal before the city council. Well, in a way, the fact that we have this technology shows that the courts are increasingly, maybe 5 years ago, if you went in front of a judge, the judge might say, Facebook, what's that? Now the judges are all old enough to have been using Facebook themselves, and they all know what it's all about. And they're going to understand that there's no real difference today between a commissioner expressing himself or herself about an issue affecting the commission on Facebook as with, maybe flyers that were used in the 1980s. It's really the same thing. If it's relating to public business, then you have to keep it as a public record, which is the primary issue. If it's a county commission issue. If another county commissioner responds back to a commissioner's posting of an issue on Facebook, you can expect sunshine law issues. So what would I do as a commissioner? Well, first of all, I can't even imagine doing the job that you do every day. I'm sure people tell you that all the time. But I would be careful in using Facebook I would use it to express my position on issues if I felt it was important to get that out to the commissioners. I would probably make it so it tracks what I've already said at a public meeting rather than to announce something. I would be there, and I would keep that as a public record by taking a picture of it or keeping it in the public record. The other thing that I would do is be careful not to respond to any other commissioner's Facebook postings. I think if you do that, then that's going to cover most of the issues that you will have. If you ever see a commissioner respond, which they shouldn't, because they should have all been droned at, if that's a word, by your county attorney like I have. So commissioners should know not to do this on Facebook. But if they do, then at that point, I would ask the county attorney for a briefing on that issue, and I would probably be reluctant to post on Facebook if other commissioners were going to disregard the views of the county commission and post. I see less of a danger with Facebook, frankly, because of its public nature, as opposed to emails, which always look more sinister. I mean, frankly, that really is, I think, something I would always avoid, copying commissioners, et cetera, on emails without it being posted somewhere. But Facebook, I can see people feeling like they have to do it to get information across. Yes?
Hypothetical.
Oh.
Well, or maybe three. There's two of us that serve on the board that have been friends, and our families have been friends for many, many years. We hunt together, we fish together, we've gone snow skiing together. Now, we may not do that anymore.
No, you can still do. The question is, can we still hunt, fish, go snow skiing, all of which sound like a great deal of fun together, even though we're both on the county commission? Yes, but what you would probably want to do is realize that members of your community, if they see you fishing together, especially if there's a big issue coming up that affects them, because you know how it is, it's a matter of human nature. Everybody thinks their issue is the most important thing that's going on, and you and your friend can't possibly be just fishing. You have to be discussing how you're going to affect this person's whole life and family forever. So I think you're just going to have to expect that people are going to do that. But I suspect the people that voted for you and your friend know that you've been friends for years and years, and they voted for you anyway. But just expect that. One thing I would recommend avoiding, and this is something a lot of people do sometimes without thinking, I would avoid having breakfast or lunch with other commissioners the day of the commission meeting or a big workshop or things like this. the public always feels that there are discussions taking place regarding their lives and families, and that public business is being discussed. And there have been cases where, I remember the Tampa City Council for years used to have a private lunch. You remember, people that remember this, for years it was supposed to be purely social, and I'm sure it was until one time there was the city council was meeting, and one of the councilmen was discussing an issue and said, remember Joe and I, we just discussed this over lunch, it's this. And then that's one of these situations where a hush really falls over the entire room. So I have seen this happen, the pre-meeting gatherings or lunches or breakfast. While not illegal, if no public business is discussed, I'd recommend avoiding. Yes?
I have a question about board appointments on the school board. The chair would make appointments to various committees, and they would talk to us about what committees we wanted to be on. And we were told that was not a sunshine violation because it wasn't a vote that got voted on, that was the chairman's department. Is that correct? Is that the same on that kind of committee?
You know, when I'm asked that, the question is, what about the chair talking with board members about what committees they want to be on? When I've advised boards, I've said those discussions have to be in public. Primarily, not just because of the Sunshine Law, but also because I think it sort of gets people out into the open as to what they really want to do and sort of makes it a little bit fairer. But I think other attorneys feel differently, and like with so many different things, attorneys are going to look at this differently, and I can see where your attorney must have felt that because the appointments are made solely by the chair and are not ever something that the board as a whole would vote on, the Sunshine Law was not impacted. But my view is it's too hard to know. During those discussions, you might drift in to something that's substantive, but...
Well, I noticed the last word on that slide that you had was board action. Is board action always a vote, or is a board appointment appointments?
Well, the board appointment, it sounds like for school boards, or the appointment of chairs is something that I'm sorry, every time I try to fix it, I say it wrong. We must have to adjourn soon for incapacity of the speaker. But when the chair makes the appointments, I think the reasoning of the attorney was this was not an action by the board. So that was his or her basis for the conclusion. But in my view, the definition of foreseeable action by the board doesn't just mean a vote. If it's a board determination, like for example, a board workshop, even though no votes are taken, can still be subject to the Sunshine Law. Sometimes boards discuss things because there's something that a board wants to take a position on, even if it's not a vote, and those come within the Sunshine Law. To me, it's very hard to visualize a circumstance where two board members can talk to each other about something affecting the board. The circumstance that your attorney pointed out may be one of them, and some of them do look at it that way. Our opinions in the Attorney General's office are advisory only. What I really try to do here, more than anything, is explain what the cases have said, those things that are definite, what must be done under the law. There are some other areas where you may get a different point of view from your board attorney, and if the courts haven't ruled on it, then that's something that I would continue to do. If it's a choice between following what I said and following what your attorney says, then I would always choose your attorney. That person that's their responsibility, both ethically and what you pay them to do. Now, feel free to tell them, as you sometimes do, well, this person, so many of them know me, I think practically all of them know me. She said, you're wrong. People do like to do that. Sometimes it's fun to tweak these county attorneys. Feel free to do that. I like it when they call me and say.
With that, if we have any other questions, our staff can write them down and we'll get to them after.
Thank you so much. It's been such a pleasure.